Good morning, everyone. I would like to welcome you to Assembly Judiciary. Welcome everyone here in Carson City and anyone watching online or through Nellis or our YouTube station. Just a reminder, please make sure everyone turns off anything electronical so that it's not a disruption. Just a friendly reminder too that we ask that no one approach the dais, and that when you are preparing for your presentations, that you make sure that all your materials for your presentation are submitted to our committee manager by 12 p.m. the day prior to your presentation. With that, Secretary, please take the roll.
Assemblywoman Bill Ray Axelrod. Assemblywoman Cohen. Assemblywoman Considine. Assemblywoman Gallant. Assemblyman Gray. Assemblywoman Hanson. Assemblywoman Hardy. Assemblywoman LaRue Hatch. Assemblywoman Marzola. Assemblywoman Mosca. Assemblywoman Newby. Assemblyman Ortliger. Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here, and please mark Assemblywoman Hanson and Assemblywoman Newby absent excused. With that, today we have two bills, and we are going to take them out of order on our agenda. We will start with Assembly Bill 388, which is sponsored by Speaker Steve Yeager, and it makes an appropriation to the Department of Sentencing Policy for the purpose of funding certain grants awarded by the Nevada Local Justice Reinvestment Coordinating Council. Speaker, I see that you have someone co-presenting with you, and I know that you will introduce him. And with that, Speaker, of course, I must say it's always good to see you back in Judiciary. But with that, your hearing is open, so please proceed when you're ready.
Thank you so much, Madam Chair, members of the committee. My name is Steve Yeager. I represent Assembly District 9. It is good to be here with you this morning. And I have Mr. Garrett Pruitt with me, who is the district attorney here in Carson City. So I will present the bill as briefly as possible, and then I'll hand it over to him for some remarks. But again, I want to reiterate, it's nice to be here. Happy Friday to everybody. It feels like it's been a very long week, so I'm happy we've arrived here. So Assembly Bill 388, which is in front of you, makes an appropriation of $3 million. But really, before I think I can talk about that appropriation, I need to give a little bit of a history lesson and a rundown of Assembly Bill 236, which was the Justice Reinvestment Initiative from the 2019 legislative session. I'm not going to spend a lot of time talking about what was in that bill, but I do want to talk about the driver of that bill, where it came from, and a specific provision of the bill that results in the legislation in front of you today. Now, I realize with the legislative turnover, only a handful of people that are still on this committee were here in 2019 when this committee vetted that policy. I think maybe 3 or 4 of you were on this committee then. So for those of you who weren't, I want to just give you a little bit of background, because a lot has been said about the bill over the past 3 or 4 years, but I want to give you some facts about it. And by the way, you have a number of handouts, or excuse me, a number of exhibits that are on Nellis that I posted. I did not bring paper copies because I wanted to save the trees this morning, but I will reference some of those, and certainly you can look at them at your leisure. So I want to start with a letter from the Office of the Governor that you should have there. Back in 2018, our state leaders, led by Governor Sandoval, sent a letter asking for help. They sent a letter to the federal government asking for technical assistance from the Crime and Justice Institute, which is a private-public partnership between the Bureau of Justice Assistance and the Pew Charitable Trust. And the reason that letter was sent, and by the way, it was signed by the Senate Majority Leader, the Speaker of the House, and the Chief Justice of the Supreme Court as well. So this letter is dated May of 2018. They asked for assistance to help with Nevada's ongoing efforts to effectively use government resources to reduce crime, enhance public safety, and increase opportunity. The letter's 3 pages long. I'm not going to go over all of it, but they highlighted a couple of things that were going on in the state of Nevada. They had indicated that over the last decade, the Department of Corrections budget had seen an increase of 12%. The parole and probation budget had grown 28%, and that those costs were driven by a growing prison population, where they had seen an overall increase of 11% in the prison population between 2010 and 2016. And they noted a staggering 35% growth among female prisoners at that same time. So they asked for help because they were projecting an additional 15% growth over the next 10 years. And they noted that that growth in prison population had not resulted in improved outcomes, that recidivism rates, reoffense rates still remained very high in the state. And frankly, I think the state leaders were worried about the cost to the state. There were proposals that we would have to build new prisons in the state if that population continued. So ultimately, the letter asked to help with a rebalancing of Nevada's public safety portfolio. And so that letter was sent, and thankfully Nevada was chosen for that technical assistance, and thus started a very long process that took probably about 14 months, where folks came into our state, looked at our system, crunched all the numbers, ran all the data to figure out how we can do things better. Now, where I come into the picture here is the Advisory Commission on the Administration of Justice, which was a committee that would meet in the interim. It doesn't exist anymore. But that was the committee tasked with handling this work in the interim before the 2019 session. Now, this committee had just about everybody and their brother and their mother on it in terms of criminal justice folks. We had Supreme Court justices, district court judges, justice court judges, district attorneys, public defenders, victim advocates. The Attorney General was on it, and we actually met after the election. So first it was Attorney General Adam Laxalt, and then after the election it became Attorney General Aaron Ford. And so the idea was to figure out what we could do better. And that process took a very, very long time. And I want to thank the legislative staff who had to staff all those meetings. And we had a lot of meetings. So ultimately we got to the 2019 session and we finally got this bill, AB 236. It was a very large bill, a lot of things in there. The bill, like many bills do, went through the legislative process and had a lot of changes, which is to be expected with a bill of that magnitude. Ultimately, the final version of the bill received bipartisan support. At its final hearing in the Senate, nobody testified in opposition to the bill. And in support were more traditionally conservative groups, such as the Chambers of Commerce, the Retail Association of Nevada, the Trucking Association, and Americans for Prosperity. The Metropolitan Police Department from Las Vegas had been opposed to the bill originally, and they came in neutral after some changes were made. But I did want to point out that there was one other letter that was sent that I don't know if all of you have seen or not, but the original version of the bill, again, before it got changed, there was a letter of support that came in from some, I would characterize as very conservative groups around the country. And that letter advocated for members of the legislature to support the initial version of the bill before it was amended to address some concerns. And, you know, the authors of this letter, R Street, the American Conservative Union, Americans for Tax Reform, Faith and Freedom Coalition, Freedom Works, Right on Crime, they had indicated that Nevada was projecting a 9% increase and that the taxpayers would pay $770 million more over the next 10 years if we didn't pass some reforms. And I just wanted to note quickly, again, I'm not going to read the letter. I know you all know how to read and you can do that, but they had mentioned that the recommendations that we had in the bill had proven successful in many states like Texas, Georgia, South Carolina, Mississippi, and Utah, and that by adopting the recommendations of the Advisory Commission, and I will quote from this, by adopting the recommendations of the Advisory Commission, the legislature can follow the lead of President Trump and conservative states across the country, getting Nevada's justice system back on a sustainable track. Now, the reason I read that to you is I very much believe, as I always have, that criminal justice reform is not a partisan issue. If you look around the country, there are conservative states and there are liberal states that are doing criminal justice reform. It is a matter of how do we use government resources effectively, how do we get outcomes and results. And so I just wanted to give you that little bit of a background of sort of where AB 236 came from and how it ended up passing into law in 2019. Now, I will mention, as many of you know, we had something really cataclysmic happen in the country in March of 2020, and that was the pandemic. Most of the provisions of Assembly Bill 236 did not go into effect until October of 2020. So some of the promise of AB 236 has not really been realized because of the pandemic and the disruption. Because AB 236 had a unique provision in it. It was called the Justice Reinvestment Act. And so just by the language itself, the idea there was we would take those costs that were avoided, the $770 million as initially projected, and then I'll update that, but we would take those avoided costs and we would reinvest them in the justice system, on the front end of the justice system, to try to help people not have to go to jail, not have to go to prison. So part of this bill requires a tracking of how are we doing in terms of avoiding those costs. In 2019, again, it was projected that if we enacted this bill, $640 million would be saved essentially in the next 10 years. And that's corrections costs. That's building new prisons, that's staffing prisons. And so AB 236 included a mechanism to measure the outcomes and asked the Sentencing Commission, which I think now is the Department of Sentencing Policy, so we've had some changes in the state since then, to collect and analyze data. And it also tasked the Sentencing Commission to develop a formula to measure the cost avoided and then make recommendations for how we should reinvest those funds. AB 236 also created, and this is what the purpose of this bill is, the Nevada Local Justice Reinvestment Coordinating Council, which is a mouthful, so I'll just say the council from here on out. The council is required to administer grants to fund programs and treatment at the county level. The council is comprised of members from each county. Each county appoints one member of the council, including 2 members from Washoe and from Clark. Now, I have included for you as one of the handouts the current membership of the council, and I happen to have the chair right here next to me on the left who can talk a little bit more about that. But the council has been meeting. So the next thing I wanted to point out in August, I guess in August of 2022, you have this document called Projected Amount of Costs Avoided. This is put out by the Department of Sentencing Policy. They, again, based on the current projections, they updated that number of $640 million in savings. They updated it to be $470 million in savings. Part of that was because when the pandemic happened, we had a drop in prison admissions for a lot of reasons. The commission at that point recommended intensive and focused funding to agencies and programs that would help reduce recidivism. Agencies such as the Department of Corrections, Division of Parole and Probation, Housing. Additionally, the commission at that time recommended funding of $3 million to the Coordinating Council for that purpose. As we sit here today, the Coordinating Council has not received $1 to be able to grant out money. Part of that was we had a pretty big thing happen in March, and we had to come and cut a huge portion of our state budget, so there simply weren't the funds to do it. And then just to update you, a lot of reading, I know, and I don't expect you all to do it, but if you'd like to, December 2022 Statement of Costs Avoided, this is again submitted by the Department of Sentencing Policy. They provide a full analysis comparing the projected prison population and then the actual prison population since AB 236 went into effect. And just a quick note there, I mean, we try to project the prison population years and years ahead of time, so the state generally consults with a company that does those projections. So when we came into AB 236, we sort of saw where the trajectory was going, and we wanted to figure out how do we flatten out that trajectory so we don't have to build additional prisons in the state. So the recommendation to fund $3 million was developed by the Coordinating Council. The council meets on a quarterly basis, and they have been meeting since September 27th of 2021. The council has developed the recommendation based on reinvestment in programming in other states. The Coordinating Council has also researched programs and treatment in Nevada that could be funded by the grants they would administer. Specifically, at the May meeting, that was May of this year, May of last year, they talked about the cost of establishing what's called a MOST, which is the Mobile Outreach Safety Team. In 2019, there was a bill that would have appropriated $2 million to fund those in the rural counties. Unfortunately, that bill did not pass, but funding these response teams would provide support for responding to mental and behavioral health issues for people who otherwise might be involved in the justice system. So if you think about calls coming in to 911, sometimes you can send a behavioral health professional out there and avoid having to arrest the person, avoid having to put them in the hospital. So to get to the bill, it's pretty straightforward as bills go. It proposes $3 million. I think it's an exciting step in marking the progress and success of Assembly Bill 236, but it also fulfills the promise, which is reinvestment. If you don't reinvest, you're not going to see the results of what this body did in 2019 in AB 236. And before I hand it over to Mr. Pruitt, I did want to note, I was hoping we could get him here in person, but travel plans did not allow. But I did submit a letter for the record, a letter of support, which I don't know if I have in front of me, but it is a letter of support from the chair of the Utah Council, who does similar work. Their name is different and just as long as ours, but they do some good work as well. So you have a letter, and Nellis, of support from him, advocating for us to fund our coordinating council to get the results that they have seen. So I would obviously urge your support, but before we take questions, I want to hand it over to my esteemed guest, who thankfully didn't have to travel very far this morning. But first, thank him for the work he's been doing on the council, and allow him to make whatever comments he would like, and then we'll take questions. Thank you, Chair.
Good morning, Garrett Pruitt for the record. As was stated, I'm the chair of the Nevada Local Justice Reinvestment Coordinating Council. Our provisions, or our purpose, is set forth in NRS 176014. We get about 7 subsections of statute that more or less set out what we're supposed to do. And I can tell you the first few sections of those is simply who will make up the council. We get about 1 line that says, our purpose is to identify county-level programming treatment needs to reduce recidivism. So as was noted, our council is made up of members from all across the state. We have some that are county commissioners, we have district attorneys, we have public defenders, we have other stakeholders in the criminal justice system, from court personnel to counselors, all sorts of different members to make sure that we have the most full perspective that we can on the situations that we have before us. So what the council's been up to for the last approximately 2 years is first determining exactly how it is that we would set forth what we need to do. So where are the issues that we had? And what we found consistently, one of the areas that contributes greatly to our recidivism problems is obviously areas that involve mental health, absences of treatment, or holes that are associated with that treatment. But because we're composed of persons throughout the state, we also noted that the issues that may plague Clark County or may plague Elko are far different than what may plague us here in Carson City. And so what we're designed to do is essentially plug those holes on a local level. There's lots of different types of legislation that obviously can address issues on a statewide level and appropriate funds necessary to do that. But what we're designed to do, especially with the grants that we would have, is allow different counties to apply for grants that would address or plug the holes in their local community. So we've had issues that came up where, you know, in some of our rural jurisdictions, simply transportation in order to meet mental health appointments or other substance abuse counseling appointments was their issue. Not the same issue that we may have in Carson City, given just the size of our jurisdiction is so much smaller. Most of our things are within walking distance. So that issue is different for us than it would be for them. And so what we would do is we set forth an umbrella of this is the type of funding that would be available. Now, the other thing that we had to look at was how do we track this? So we've had quite a few presentations from different groups, and one of those that we have more or less settled on with the Department of Sentencing Policy is a tentative partnership with Justice Counts, who can keep track of some of the data to determine if we're spending this money, is it really helping and doing what we want to do? We certainly understand that not everything is perfect. Our goal obviously is to reduce recidivism in each and every way that we can. And so as we look back, if we do award a grant, if we're awarded that money from the legislature, that we're going to be able to track, did this accomplish its slated goal? If it didn't accomplish its slated goal, obviously it's not something we're going to renew or something we would continue to pursue. So in arriving at the number before the court, we started looking, or excuse me, not the court. I spend most of my time in court. I apologize to the committee. So in arriving at the number that we had, we looked at the similar type of committees that we are as they are in other states. And so many of that, I should say the way they're composed is very similar. They operate under a same rubric. The amount of budgets that they have varies widely. We have some that deal with upwards of $300 million, down to some that deal with $3 million or just a little bit less. And so we started on, I guess you could say, the smaller approach to that, looking to plug those holes instead of being essentially an umbrella that administers all this money across the state so that we can fine-tune our processes. And so that's how we arrived at the number that we have before this group today. And so it is our goal to start plugging those holes in each of the communities so that we have a reduced recidivism amount and that we can finally tailor the solution to each county as they need it. Thank you.
Thank you, Madam Chair, Steve Yeager, and again, want to thank Mr. Pruitt for his work. I know in groups like that, it can be hard to get everyone on the same page, so appreciate his efforts, and we would be available to take any questions at this point. Thank you.
Thank you so much, Speaker, and thank you for your presentation. With that, we will open up questions with Assemblywoman Mosca.
Thank you so much, Chair, and thank you, Speaker, for this very important piece of legislation. I really appreciate as well the focus on outcomes to show the impact. Just a quick question, if you can share, you kind of touched on it, but what kind of nonprofit organizations, if there are specific ones we're thinking of or who have approached, and will it include in-state as well as out-of-state, or just in-state nonprofits?
Garrett Pruitt through the record, Assemblywoman Mosca through the chair.
Oh, please go direct.
What's that?
Please go direct.
All
to the
right, will do.
Assemblywoman,
Thank
yes.
you. All right. So what we've considered, when we're looking at the partners that we have, most of the ones that we have found have been on the local level because they're in the best position to administer the help that's needed. So I can probably give you the best examples of those here in Carson City because that's where I work and what I see. When I think of the mental health options that we have available for people, apart from the Mallory Center that we have here in town, there are several programs. We have a program called the ACT program, which deals with persons on an outpatient basis for mental health who have been diverted by our MOST team to those types of programs. Another one that we have is a group called First Psychosis, who helps individuals who are perhaps experiencing their first psychosis episodes as an adult to then reintegrate, avoiding the criminal justice program altogether. So it's not that we would be opposed to something outside the state who's willing to come in and provide those services, but what we are going to want to see is someone who is there with the present ability to make the difference now as opposed to looking at something way out in the future.
Thank you. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation, both of you. Speaker, if you could just address the work that will be done when the reports come in to interim finance and Leg Commission, and even talk a little bit about our legislative auditors and that team and the kind of work that they do.
Steve Yeager for the record. Thank you for the question. If I'm not mistaken, Assemblywoman Cohen, I think you actually chaired the hearing on Assembly Bill 236 back in 2019, I think. So thank you for that. It was a long hearing. I remember that morning. But the question is a good one. So basically, this money gets appropriated to the council can grant it out, but there is some reporting that comes back to the legislature, and particularly to the Interim Finance Committee, which I think most of you know what that is, but if you don't, there's a committee that meets a couple committees that meet in the interim. One of them is the Interim Finance Committee that deals with money, and generally that's when state agencies have emergencies and they need additional funds. But so there will be a reporting that will be made, so the Interim Finance Committee knows what the money was spent on. And basically how it was used. And I think some benefit there, obviously, is, we didn't really touch upon this, but in a sense, these sort of local grants that are made, if we start to see things that are very successful, maybe things we want to replicate on the state level. We may not, because maybe they're individual to the counties, but so there'll be a reporting and an accounting. And then the next part of the bill, which is on page 2, subsection C, talks about the Legislative Commission. Now, the Legislative Commission is another interim group that meets, and they really deal with regulations. They don't deal with the money so much. They deal with the process. And so under this particular bill, the Legislative Commission and its auditors, if they have concerns about the way that the money was spent, this requires any grantee agency to provide information, provide their books, basically let our auditors come in and make sure that the money was used the way it was supposed to be used. And I don't know how many of you have experience with our legislative auditors, but I will tell you I think they are absolutely the best in the business. With all the free time you have, you should definitely go on their website and read some of the reports, because one of the great things they do is they really do performance audits. They go in and look at programs and not just say the money was used, but here's how we think you could do better. And they generally make recommendations, generally to state agencies. So in this circumstance, if we needed them to come in, they would have the ability to do that. And I think that's the safeguard to make sure that the state's money of $3 million is being applied as designated by the council, and that there's a safeguard there to be able to come in and look at it if we have any concerns.
Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you so much for bringing this. I think that this is really critical, and I appreciate this investment on the front end to try to catch problems before they become much larger. I know we have the letter from our neighbor to the east, and you mentioned that this is in other states. What I really like about this is this idea that there's local investment and you can try new things and you can see how they work. I just wondered if you have any data, and you might not have it today, but if you have any data on how this has improved, criminal justice systems or recidivism or anything else in the other states that have done this.
Garrett Pruitt for the record. So our council does have data on this subject, and we can provide that to the committee. So we have seen several presentations from other states. The most recent one we had was from the state of Oregon. Obviously, the programs they're administering, many of them are different than when we may administer here, but they're one of the ones with the largest budgets. I think they deal with over $380 million a year in grants. And so what they do is when they track their stuff out, they keep track county by county of how the recidivism numbers are affected. They do it a little bit on a macro scale, and not in the sense of, did this one specific program, is that the right one contributing statewide? But what they've looked at and what they've been able to track is, okay, we've awarded this much money to this county, and then they look at those numbers. Are they reducing? Are they staying the same? Are they going up? And that determines how much money may be awarded to those counties in the future, so we can get that information for you.
Thank you for that. And could you submit that to the committee? Because I know everyone would be interested in that data.
Yes, we can.
Thank you so much. Our next question is from Assemblyman Gray.
Thank you, thank you, Madam Chair. Mr. Pruitt, just a quick ask for you, sir. I noticed in the roll call sheet, Lyon County has not filled my seat yet, so please reach out to them and get Andrew Haskin, the county manager, to fill that seat on their next agenda. So I enjoyed my time on there. It was good. They're doing good work, and I really appreciated that opportunity, so thank you.
Thank you.
Thank you. Our next question is from Assemblyman Urick.
Thank you, Chair. And I really appreciate the efforts to be proactive, especially in the area of, it seems like the priority is mental health issues. One of my colleague asked for some data to see how this has actually helped in other jurisdictions, but just to help me kind of understand, can you give us just a couple of examples of the types of programs, or when these grants have been given to local entities, the types of programs that they have done that have targeted mental health, to give us an idea how this money might be spent to get the results that you're telling us have been achieved?
Garrett Pruitt for the record. So one of the areas that we saw was an expansion of what are called MOST teams, mobile outreach safety teams, which is the pairing of an officer generally with a social worker to respond to mental health calls. And so, as this body is likely aware, there are several MOST teams that are in most of our larger counties throughout the state. Not all of our smaller counties benefit from having MOST teams, and we've seen them deployed in many other states. So I can say that here in Carson City, we've had those teams for many, many years now. It was a priority for our sheriff. And what it has done, so when an individual calls who's in mental health crisis, generally that MOST team is the team that is set out to respond to that incident. Now, it has reduced the amount of arrests that have taken place. Every so often, depending on what's happening, sometimes an arrest does take place if things escalate to a level that we wouldn't want to see or that become a public safety issue. But a lot of those people, MOST takes a lot of people to Mallory. They otherwise connect them with family members. They're able to do a lot of things that otherwise had not been done traditionally. So we saw funding used for that reason in other states. We also saw an expansion of just simple treatment services. One of the portions that I believe I saw was in Washington State was an expansion of telehealth. So obviously the majority of the mental health providers have been congregated in larger cities, leaving rural jurisdictions with less access to those. And so in one of the small counties, I think it was in rural Oregon, it was simply setting up a computer platform in an area that was safe where they could participate in those telehealth appointments. So that's why I say the local needs vary so much, and that's why some of the other states, they experience many of the same issues that we do have. And so by allowing the counties to basically submit their proposals, it allows them to address the problem they have.
All right, thank you for that. With that, I don't see any additional questions. And so I will open it up for testimony in support of Assembly Bill 388. If there's anyone here in Carson City that would like to testify in support, please approach. Please remember to state your name and spell it so that it's accurate in the record.
Thank you, Chair, members of the committee. My name is John McCormick, John-McCormick. I'm the Assistant Court Administrator at the Supreme Court, and I am appearing today in my capacity as the AOC's appointee to the Sentencing Commission, and on behalf of Chief Justice Stiglitz, who is currently the chair of the Sentencing Commission, to throw our support behind this bill. I think Speaker Yeager kind of covered everything, but I would just like to indicate that this is continuing, I think, the intent that started with the creation of the Sentencing Commission and some of the stuff in AB 236, and it's an important step forward.
Thank you, Madam Chair. John Puro for the record from the Clark County Public Defender's Office. AB 236, like Speaker Yeager said, was a watershed moment that most of you are here to help get across the finish line. Moving forward in a data-driven fashion and reinvesting those funds so that our community becomes safer, our recidivism rate goes down, and that things become better for our citizens is absolutely essential to moving forward. And this bill would help accomplish that goal, so I urge your support. Thank you.
Is there anyone else here in Carson City? Broadcasting, is there anyone on the line?
To testify in support of Assembly Bill 388, please press star 9 or raise hand in your Zoom window to
take your place in the queue. Again, if you'd like to testify in support of Assembly Bill 388, please press star 9 or raise hand in your Zoom window now.
Good morning. Tanya Brown, spelled Tonjagrown, advocates for the inmates and the innocent. We strongly support this bill. We would like to thank Speaker Yeager and the presenters for bringing this very important piece of legislation forward. I'm just going to echo everybody's comments about this, and I would just like to add that anything that would help recidivism, to reduce recidivism, would be beneficial to the taxpayers in the state. Mental health is a huge ongoing problem, and we really need to reach out and get the support. And most people don't know this, but I did have a brother, brother who suffered from mental health problems. He was a paranoid schizophrenic. About a year and a half ago, I received a call from the Lyon County Sheriff's Office that they had found his body. He was homeless, living under the bridge in Dayton, and he suffered from mental illness most of his adult life. So funding this kind of legislation would be beneficial to everyone, to those with mental health issues, family members, and again, you will hear officers tell you they are not equipped to deal with mental health issues. And a lot of these people wind up seriously injured and some dead because of this. So we strongly support this bill. Thank you very much. Have a good day.
Thank you, Ms. Brown.
Clinton Zenz for the record, ClintonZens. I am actually the Nye County representative for the Reinvestment Coordinating Council, and I certainly wanted to get this opportunity to voice my support for this bill. Being a mental health professional myself in my county, my very rural county, for the last 10 years, I find it very exciting that this concept is even up for debate, and the thought of getting grant funding that can bolster our mental health capacity to help the people of Nye County, which is greatly needed to be able to help the sheriff's office with a mental health professional to respond to those crisis calls instead of a police officer going out and ultimately having to make an arrest for not really being able to handle the situation otherwise is very exciting to me, to us. So just again, echoing everybody's comments and definitely in support of this bill. Thank you.
Anne Marie Grant, on behalf of Advocates for the Inmates and the Innocent, I echo the other testimony of those in support of the bill, and I support the bill. Thank you.
Good morning. My name is Julia Murray, Juliamurray. I serve as both a member of the Nevada Local Justice Reinvestment Coordinating Council on behalf of Clark County, as well as a commissioner on the Nevada Sentencing Commission on behalf of the Clark County Public Defender's Office. In addition to that, I work daily as a direct participant to the criminal justice system as a Chief Deputy Public Defender at the Clark County Public Defender's Office. I'm here today to voice my strong support for AB 388. The Coordinating Council, since September of 21, has been actively engaged in researching and collecting information, both from direct members of the counties it represents, but also from agencies statewide and out of Nevada. The reason for doing so is because AB 236 relies on data in order to see its full potential come into capacity in reducing recidivism in the state of Nevada. The next step to this is funding. Without funding, we are unable to move forward and achieve our next goals, assisting the actual communities of this state in addressing their individual recognized needs in accessing transportation, counseling, whatever it may be that will allow each county to look at their issues that affect recidivism and address them head on. I look forward to helping entities and organizations in each county across the state apply for funding that is offered if this bill is granted. This money will show direct impacts to the people of our communities. And while I am excited to see what this money could do for a county such as my own in Clark County, I am significantly more excited to see what this money can do in the areas of Nevada which truly lack resources. Our smaller and rural counties have access issues. This money can directly change that. Your support of this bill will allow the Coordinating Council and in turn the Sentencing Commission and in turn the people of Nevada to take an active step against continued acts of crime and towards reducing recidivism in our state. Thank you.
Good morning, Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office, calling in support this morning. I want to thank the speaker for bringing this forward and simply echo the comments of my colleagues in the South, and I urge your support. Thank you.
Callers, if you have recently joined and would like to testify in support of Assembly Bill 388, please press star 9 or raise hand in your Zoom window to take your place in the queue.
Hi, this is Demar Dahl, D-E-M-A-R, last name Dahl, D-A-H-L, representing Elko County on the council. We in Elko County strongly support AB 388 and would appreciate your support also. Thank you.
Chair, there are no other callers choosing to testify in support at this time.
Thank you so much for that. Then we'll move into testimony in opposition of Assembly Bill 388. If there's anyone here in Carson City that would like to oppose? Not seeing anyone. Broadcasting, is there anyone on the line?
Callers, if you would like to testify in opposition to Assembly Bill 388, please press star 9 or raise hand in your Zoom window to take your place in the queue. Again, if you'd like to testify in opposition to Assembly Bill 388, please press star 9 or raise hand in your Zoom window now. Chair, there are no callers choosing to testify in opposition at this time.
Thank you so much. Then I will go ahead and open it up for testimony in neutral of Assembly Bill 388. If there's anyone here in Carson City? Not seeing anyone. Broadcasting, is there anyone on the line?
Callers, if you would like to testify in neutral for Assembly Bill 388, please press star 9 or raise hand in your Zoom window to take your place in the queue. Again, if you would like to testify in neutral for Assembly Bill 388, please press star 9 or raise hand now. Chair, there are no callers choosing to testify in neutral at this time.
Okay, thank you so much. Then with that, I will welcome Speaker Yeager back up for any final remarks.
Thank you, Madam Chair, committee member Steve Yeager, for the record. I'm excited about the support that we heard. We heard support from all across the state, and I think that probably tells us we're doing something right. I want to express appreciation for those who serve on the council, and I did forget to mention that Assemblyman Gray was on the council before he became a member of this body, and I'm sure they'll get that seat filled really soon. So again, it's reinvestment, right? And it's hard sometimes because what we're doing is we're avoiding spending money. So it's not like we got that money. It's not actual savings, but it can be hard philosophically to say, well, let's spend that money on something else. But that was the central premise of justice reinvestment. You save, you reinvest, and hopefully you solve some of these problems. The latest projection is that we're going to save $470 million over the next 10 years. This appropriation is $3 million, so it's less than 10%. My math's not great. It's probably 7 or 8% of what that projected savings is. But my hope, my sincere hope, is that if this were to be approved, we'll be back in front of you or another committee next session and hopefully asking for more, because we're able to demonstrate that this actually worked the way that it was intended. And so I just see that as a win all around the state, and very much appreciate the time of the committee this morning to be able to talk a little bit about something that happened 4 years ago, which now feels like 40 years ago. But again, appreciate your time and always willing to answer any questions if you have any after the committee meeting ends today. Thank you so much, Madam Chair, and thank you, committee members.
Thank you so much, Speaker. Always a pleasure to have you back in this committee. And with that, I will officially close the hearing on Assembly Bill 388. With that, our next hearing is Assembly Bill 381. And this bill is presented by Assemblyman Nguyen and okay, I'm going to let Assemblyman Nguyen introduce all who is co-producing, look at me. Yeah, that's wrong industry, right? I believe Ms. Bookout and just who all is participating in your presentation. With that, Assembly Bill 381 revises provisions for governing guardianship. And Assembly Bill 381, the hearing is officially open, so please proceed. And Assemblyman, do you also have someone else on Zoom present? Okay, or it's just the three of you? Okay.
There is one more guest, Chair Miller, but he's here in Carson City.
Okay, so please just introduce it. So will it be kind of musical chairs? Is that what is going to happen? Okay, thank you. Please proceed.
Good morning, Chair Miller, Vice Chair Marzola, and the rest of the Assembly Judiciary Committee. Thank you again for your indulgence this morning. My name is Yui Nguyen, for the record. I proudly represent Assembly District 8 in Southwest Las Vegas. Here beside me is Mr. Jonathan Norman, Statewide Advocacy Outreach and Policy Director with the Nevada Coalition of Legal Service Providers, and Ms. Deborah Bookout, Directing Attorney of the Guardianship Advocacy Program with the Legal Aid Center of Southern Nevada. And in the audience, we would also have the expertise of District Judge Egan Walker, who served as the co-chair of the Guardianship Commission and has been a strong support of guardianship realm ever since. Adult guardianship matters hit close to home in my district. I represent the most culturally diverse district in the state, so many of those families observe the tradition of caring for their loved ones in their home as they grow older. Nevada set a national standard for adult guardianship with groundbreaking reform implemented in 2017 with the advent of the Protected Persons Bill of Rights. This has been vital for alleviating the barriers faced with adult guardianship. Former Speaker Barbara Buckley has even stated that in some cases, guardianship was being filed against vulnerable adults by people they have never met before in their lives. Empowering these individuals with the support of affordable legal counsel was the first step, and AB 381 takes it further by protecting the rights and interests of vulnerable adults throughout every step of the guardianship process. These advances align even more with the Patient's Bill of Rights in the way of helping preserve individual independence, privacy, and the ability to correspond and visit with people, having their financial and healthcare wishes carried out as they choose, and justify restores rights and autonomy to those seeking to terminate a guardianship. Right now, it is still harder to escape guardianship than it is to be placed within one, or at times, as I've mentioned, have one forced upon you without your consent. AB 381 preserves both their dignity and autonomy throughout the process that were set forth through those first reforms and enshrined protections even further. When a court appoints a guardian to make a decision on behalf of an adult, we need to instill checks and balances that will ensure they are put there because of an appropriate, verified need, and that a guardian also must be held accountable to not take advantage of the person appointed to their care. Strengthening the system with transparency and oversight will ensure even more that their lives and livelihoods will not be trampled upon. Now I would like to turn it over to Mr. Jonathan Norman, who is a strong advocate for this work and can go over more background on the bill. Thank you, Chair.
Chair, members of the committee, Jonathan Norman with the Nevada Coalition of Legal Service Providers, NORMAN. I want to thank Assemblyman Nguyen and thank this committee for hearing us today. I'm not going to go over some of the comments that I had because I think the Assemblyman covered them. I will say that, when I think about adult guardianship in our state, I think of like 2 points in time. I think of the New Yorker and I think of Bloomberg. And the reason I think of those is because they both published articles on the state of guardianship in Nevada. The New Yorker article came out some time ago and was highly critical of the abuses that were happening to people in guardianships that were approved by the courts, and the Bloomberg article highlights where we are today and all the good work that's been done by the Guardianship Commission and advocates around the state. And I think, I want to make it clear, we have these reforms, but I think we're a model in the country for how guardianship should be done well, and I think that's through the hard work of our attorneys at Legal Services and the Guardianship Commission. So this bill, it seeks to, the Protected Persons Bill of Rights, it balances and I should back up a minute and make sure we're all on the same page. So when we say protected person and proposed protected person, like simply put, if somebody is not able to make decisions and take care of themselves, so if my father is aging and is not able to make decisions for himself and I file a guardianship, at the point I file a guardianship, my dad is a proposed protected person. Once that guardianship is granted, he is a protected person. A thing that I think gets missed is sometimes people think you're under a guardianship so you have no rights. But our state has decided and is committed to preserving as much individual liberty for that person that is appropriate given their unique circumstances. And so you'll see in the Bill of Rights, there's words like engage in any activity the court has not expressly reserved for the guardian. Receive telephone calls and personal mail and have visitors, have privacy. Be granted the greatest degree of freedom possible. And then I edited out some stuff because it was boring. And then exercise control of all aspects of his or her life that are not delegated to a guardian, specifically by court order. So that's the balance. We're trying to protect people and preserve individual liberty. These rights are protected by the mandatory appointment of counsel for all protected persons and proposed protected persons. At any given time, so in the coalition is Northern Nevada Legal Aid, the Senior Law Program, Volunteer Attorneys of Rural Nevada, and the Legal Aid Center of Southern Nevada. At any given time, we're representing around 2,500 individuals who are either proposed protected persons or protected persons. I'm joined by Deborah Bookout, who is the Directing Guardianship Attorney at the Legal Aid Center of Southern Nevada. She manages a team of 25 individuals, 15 attorneys, paralegals, and legal assistants, and they represent protected persons, proposed protected persons in Clark County. Ms. Bookout and I presented in the interim committee on seniors, citizens, veterans, and adults with special needs on June 28th, 2022. Regarding changes we felt would bring the rest of the 159 more in line with the Protected Persons Bill of Rights. The coalition is made up of advocacy law firms, and we are grateful for the interim committee taking up this bill and to this committee for hearing it today. And I do want to stress, you know, I see these as, our guardianship statute is really solid. We are an example that other states are emulating. So these are changes, because there is room to improve, and I think these changes reflect that. So now I'm going to turn it over to Ms. Bookout to walk us through the bill. Thank you.
Thank you. Deborah Bookout, Debra Bookout. I'm just going to run through the bill real quickly for you. Section 1 requires phone and email information for the petitioner and proposed guardian be included in the petition for guardianship. Section 1 also conforms the physician certificate and needs assessment by requiring that both be included with the petition and both may be prepared by the same person. Section 2 requires that before appointing a guardian ad litem, the protected person is provided notice of the potential appointment and an opportunity to object. This section also requires the order appointing a guardian ad litem to specify the scope and duties and further requires the court to set the rate of pay. Section 3 requires the petitioner seeking a temporary guardianship identify the specific risk or specific medical need the protected person is facing. And then Section 4 requires that the court limit the temporary guardianship to the powers necessary to address those specified needs. Section 5 adds a provision requiring the court to deny a petition for guardianship where there are less restrictive alternatives available to the proposed protected person. And then Section 6 requires the court to grant a petition where those less restrictive alternatives are not available. Section 7 clarifies that professionals or other expenses do not include the fees of the guardian's attorney in the guardianship matter. Rather, those fees are compensable under another provision. And Section 8 addresses the burdens of proof involved in terminating a guardianship and further addresses fees incurred during a termination proceeding. Section 9 guarantees the protected person's right to refuse to visit or communicate with anyone. Section 10 clarifies that a protected person cannot be ordered to visit or communicate with anyone if they do not wish to. And Section 11 notes that any person opposing a protected person's wishes with regard to visitation carries the burden of proof. Section 12 further provides clarification regarding attorney tasks which are not compensable from the protected person's estate. It also prohibits the award of guardian's attorney's fees from the protected person's estate where the required notice of intent has not been filed. And the section further requires that the order awarding fees must include the reasonableness factors. And finally, Section 13 expands guardianship orders that may be appealed. And I'll hand it back to Mr. Nguyen.
Thank you, Ms. Bookout. So in closing, before we stand for question, I would just like to remind the committees on the two important things that we're trying to accomplish with AB 381. First, temporary protective orders will review the need for a guardian, setting limits to what can quickly be imposed upon without a critical need. This required that a petition for temporary guardianship must state specifically why it is needed, and only the court will have the authority of the temporary guardianship to meet that specific need. This will prevent protected person from being exploited by the very instrument meant to protect them. And second, to have legal services provided at a reasonable rate. Whenever the court ordered that attorney's fee must be paid from the protected person's life savings, they will have to consider and review a list of factors and record written finding related to those factors. This provides some protection and transparency when we're allowing a court to spend what is often the protected person's life savings. These improvements in AB 381 will restore more self-efficacy for vulnerable adults to be active participant in their life choices and will allow them to have a greater sense of dignity as they grow older. Thank you, Chair Miller and the members of the committee. We're ready for questions.
Thank you, Assemblyman, and thank you for your presentation. With that, our first question will be from Assemblywoman Mosca.
Thank you, Chair, and thank you for this important presentation. I just had a quick one when I was reading it, and you mentioned it as well in Section 4 about Section 5. What are some examples of just less restrictive alternatives?
Deborah Bookout, DEBRABOOKOUT. So the common less restrictive alternatives that we're referring to would be like powers of attorney for healthcare, financial purposes. We have supported decision-making agreements. A rep payee for federal benefits could be a less restrictive alternative. As you know, we now have powers of attorney for individuals with disabilities and individuals diagnosed with dementia. Those are the types of alternatives we're talking about.
And if I can just add, Jonathan Norman for the record, and in the Supreme Court approved forms that are available at the self-help centers, I think there's a list of some of the most common, and when the petitioner is filling out that form, they check, I think, off if those exist. So thank you for the question.
Thank you. With that, our next question is from Assemblyman Urick.
Thank you, Chair, for the question. And thank you for your continued efforts to try to find that often very difficult to discern balance between protecting this individual and giving them the freedom that we know that they all want and quite frankly deserve. I agree with you, Ms. Norman, that Nevada really does have some amazing statutes, and this is all on the heels, I know, of the Commission to Study Guardianship and the eventual appointment of the Permanent Guardianship Commission. My question is, was that commission, did your coalition consult with that commission and get their thoughts and input into what you're proposing here, and if so, what did they say?
Jonathan Norman, thank you for the question. So Assemblyman Nguyen had mentioned that Judge Walker is in the audience. He is one of the co-chairs of the current commission, and I think he was there when the Deep Magic was written. So he was part of the original Guardianship Commission and had I don't want to say a hand. I think he may have written our statute that we're operating under, so more than a hand. And we presented to the interim committee, and I think it's a fair criticism that we did not include the commission maybe as fully as we should have. We did brief the commission on our goals, but as you know, when language gets dropped, we're on a compressed timeline. So our team was digesting that language at the same time, I think, as the commission. I don't think it was not an agendized item in a commission meeting. And just to be clear, Judge Walker, I believe he'll get up and speak for himself, but I think they have concerns about this bill, and in transparency, those concerns regard, and we're in discussions about how we can address those concerns because, we're an advocacy law firm. So when we see, law firms, when we see an opportunity to address something that we think is wrong, we're going to take it. So when the interim committee asked us to present, we presented. They asked and we submitted a bill. We're gonna run with that. The Guardianship Commission's, my understanding, their concerns are of unintended consequences, and so we're talking with them and trying to make sure that we are not creating a problem for the courts, and frankly, that would mean a problem for our vulnerable citizens, right? Because if the guardianship courts aren't functioning smoothly, that's a problem for everybody, at this table. So we're working on it. Could I have done better in the off season? I think so.
I turned it off. Thank you for that. Our next question is from Assemblyman Gray.
Thank you, Madam Chair. One of the biggest questions that comes to my mind is preventing the family or the petitioner from using funds, estate funds, to pay for the attorney's fees. a lot of families that may need to seek guardianship, they're not going to be able to afford it, especially in like the rural communities. And, there's other issues too, but I see that as a big barrier where you may have people just continue to be taken advantage of by outsiders of the family because there's no way to correct the situation.
Thank you for the question, Assemblyman Gray. And I think that, Jonathan Norman for the record, thank you. I think that hits upon a lot of our concerns and we have great forms at the Self-Help Center for people to file pro se. And always the preferences in guardianship is if there is a family member, we want that family member to have the guardianship where they are appropriate and where they want to do it. And I would say the reforms in here, like having, we're not saying that fees can't be sought, right, by the guardian's attorney. But what we're saying is that when they are sought, we are changing it to from like a may look at this list of factors to shall, and we'd like written orders. And I think, fundamentally I think our courts do a great job by and large, right? But I think when we're talking about someone's life savings and when we're talking about a branch of government potentially having the protected person's life savings spent on something they do not want, we should have that in a written order that we can look at.
Quick follow-up, please, Madam Chair.
Proceed.
So we've heard in this committee about people being taken advantage of through scams and stuff like that. A lot of times that's exactly what the family members are trying to prevent, or the interested party is trying to prevent, is that their life savings going out the window. So it's one of those darned if you do, darned if you don't situations. And I don't know which is better at this point. Any suggestions?
Jonathan Norman for the record. I think you hit on it. It's a complicated area, and I guess the only thing I can draw attention to in the changes we're suggesting that kind of dovetails with that is temporary guardianships. We're asking that they be tailored to the precise need that's identified, and that way, because we've seen cases where somebody got a temporary orders and did exactly what you're talking about. They fleeced the person, took hundreds of thousands of dollars and disappeared based on those temporary orders. So, where the issue is a medical issue, then those temporary orders should be narrowly tailored to only give authority for that specific issue. And I think that makes that change. Are we going to catch every scam, I get calls from the IRS all the time, My parents, my dear mom will call me anytime she gets a call and say, I'm worried, do I need to respond to this? And I'm always like, no, do not answer and do not respond. So, I think it's a big challenge. I think I've heard other bills and the Attorney General talking about the work they're doing to address that. I just think it's something, we're going to be playing, whack-a-mole with for as long as people are walking this earth.
Okay, our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the work on this. I appreciate this is still a work in progress. I do want to address one of the attorney's fees issues in Section 8, where a protected person makes a petition to terminate. Sometimes the protected person does need to continue to be a protected person, and it may be a family member who or a friend who wants to take advantage in the reverse to get the guardianship dissolved. And it worries me, if you look in Section 7, when you've got if the protected person prevails on the petition for termination or modification, the protected person is entitled to seek reasonable attorney's fees from any person who opposed the petition of the protected person. And I just want to make sure that we're really clear in that language, that the court, I've seen cases where the court says, okay, this person won, but the other side, it was reasonable to oppose their motion or to oppose their case, or I want to make sure that we're really clear with the courts that they do not have to award fees just because a protected person won in that situation.
Jonathan Norman for the record. I appreciate the question on my, and it is a work in progress, so on my thing, I have my change icon next to that section. And, you know, we're still kicking around the language and how that should land and talking with stakeholders. And so we could see something change to any person who opposes the petition of the protected person. So when the guardian has an attorney, that they are not able to recover fees for their work if they are the losing side, which, you know, may be duplicative of what already exists in law. So we're still working on that, but I think your point is well taken.
Proceed.
Thank you. And then again, probably just still part of the work in progress, but I am also concerned with the attorney's fee section, with what the attorney can be paid for, making sure, you know, it was something, I don't practice normally in this field. I've done a little bit of it, but, you know, in civil attorney's fees, civil attorney's offices, some attorney's offices are small and the attorneys do all the work and they do affidavit, you know, in guardianships, they do the affidavits, they do that kind of work. And so I just want to make sure that we're not keeping people out of working in that field and working on these cases where they are offering their services at reasonable rates because they're worried they're not going to be able to recoup the cost of their services. I don't think many people are getting rich, you know, now that we've made our reforms, that people are really getting rich off of these cases, but they do want to be compensated. And so I guess more a comment than a question, but yeah, I do hope that we make sure that section is fair and that the attorneys can be decently compensated for their work.
I appreciate the or Jonathan Norman for the record. I appreciate that comment, and we'll keep looking at that and dialing it. And I think the idea is that, you know, you're billing for the appropriate work that you're doing. So if you're doing attorney legal work, you're billing as an attorney. If you're doing administrative or non-legal work, you're billing in that kind of space. So we're still working on it. Thank you.
Thank you for that. Our next question is from Assemblywoman Hardy.
Thank you, Chair, and thank you for this presentation about this issue. And I just wanted to follow up. A couple times it's been mentioned these guardianships are tailored to a precise need. And in the bill, you know, there's mention of substantial and immediate risk of financial loss, substantial and immediate risk of physical harm or medical attention. So could you just, you know, tell us what those, you know, precise needs are, just what those are, and then how long is a temporary guardianship in effect, and then can they be extended, you know, with proper evidence and things like that, and for how long can they be extended?
Thank you for the question, Jonathan Norman, for the record. I am going to punt to my colleague. Thank you.
Deborah Bookout for the record. So an example of a medical need on an emergency basis that you might see in a petition for a temporary would be maybe someone is in the middle of psychosis, but they also have diabetes and they need to go on dialysis, right? That person needs to be stabilized so they can consent to treatment. Or if they can't be stabilized, there needs to be dialysis or they're going to die, right? So the petition should specify that particular medical need, and then the order would confine the authority to addressing that specific need. A temporary guardianship is granted for 10 days, and then if there's the court will set the hearing on the 10th day or the 11th day, and then determine whether to extend it, and it can be extended. I believe it's up to 6 months, with like you said, evidence presented that it needs to be extended. But generally, they're 10 days, and then there's a hearing after the 10-day period. And I'm sorry, and for financial risk would be what Assemblyman Gray referred to as like a scam. And so what the petition should specify is what is happening financially to that proposed protected person. So if it is a scam, so maybe they've turned their, given their bank account information to someone, the petitioner would then need to specify what is happening right now that's a financial risk or loss, and then the order would be tailored to address that, so that maybe closing the bank account or freezing assets or something like that.
Okay, our next question is from Assemblyman Ornlicker.
Thank you, Chair, and thank you for bringing this important bill. I have a question about Section 10.1. Just want to make sure it doesn't inadvertently apply beyond its intent. I see this isn't a section about interaction with relatives or persons of natural affection, so that's kind of a narrow scope. But 10.1 talks about interacting with another person, which doesn't limit it to relatives or persons of natural affection. So the example hypothetical I'm thinking about is the protected person should be seen by a healthcare provider for an assessment. And this says a court shall not, under any circumstances, order that they interact with another person. So does that wording have an inadvertent application?
Well, I don't know that it does. Oh, I'm sorry, Deborah Bookout for the record. And there is language in 159-328, which is the Bill of Rights bill, that specifies like the individuals' names, like persons of natural affection, family, friends, etc. This is a little bit broader than that. The idea behind this was simply that in regards to those relationships, right, protected person couldn't be ordered to communicate with someone. Like Mr. Norman said, we're still in the process of working on language. It may very well be that this needs to conform with the language in 328. I don't know that I've ever seen a circumstance where a protected person did not want to communicate with a care provider. They might not want treatment, but not necessarily fail to communicate. So I don't know that I have an answer for you, other than it wasn't intended to address the familiar relationships as defined in 328.
And Jonathan Norman, for the record, thank you for the question. I think we can tighten that language up.
Thank you so much for the presentation. At this time, there's no additional questions from members, so I will open it up for testimony in support of Assembly Bill 381. So if there's anyone here in Carson City that would like to come forward in support. Not seeing anyone. Broadcasting, is there anyone on the line that would like to support?
Callers, if you would like to testify in support of Assembly Bill 381, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 381, please press star 9 now. Chair, there are no callers choosing to testify in support at this time.
Thank you. Is there anyone here in the room that would like to testify in opposition of Assembly Bill 381? Okay, so we have 3 seats here. You can just fill the seats up and just kind of rotate out as necessary, okay? Again, please remember to state your name and spell it so that we have it in the records accurately, okay? Please proceed.
Good morning, Chair and members of the committee. My name is Catherine Nielsen, C-A-T-H-E-R-I-N-E, Nielsen's N-I-E-L-S-E-N. I'm the Executive Director of the Nevada Governor's Council on Developmental Disabilities. Guardianship is a legal proceeding that can remove civil rights and privileges of an individual by assigning control of his or her life and aspects of their life to someone else. Many options other than guardianship are available to provide counsel, guidance, and assistance with making decisions. The principles of informed choice, person-centered planning, and self-determination dictate that adults with intellectual or developmental disabilities or other protected persons are respected and supported in making their own life decisions. Individuals who can make life decisions with support from others around them should be enabled to do so. In 2019, with the hard work of Assemblywoman Cohen, we passed NRS 162C, which confirms that people with disabilities are the best persons to make decisions about their lives. Supported decision-making is recognized as a less restrictive alternative to guardianship, whereby trusted supporters are afforded the legal status to be with adults, participate in decisions, help gather and evaluate information, consider and communicate decisions so individuals with developmental disabilities understand the situations and choices they face and can make their own decisions without the need for a guardian. The DD Council supports the rights of individuals with developmental disabilities and other protected persons to direct their own lives to the maximum of their abilities through changes to the guardianship system in Nevada that promotes the best practices of person-centered planning, informed choice, and self-determination through supported decision-making. Thank you.
Good morning, Madam Chair, committee members. For the record, my name is Steve Walker, Stevewalker. I'm representing Douglas County this morning in opposition to AB 381. I'm actually pinch hitting today for Nicole Thomas, the Douglas County Guardian, who had an unexpected schedule conflict. Her testimony is on the Nellis exhibit list for this meeting. I will not pretend I have any expertise in this issue. I'm a water guy. So I would ask the committee members to review the well-written letter, Ms. Thomas's planned testimony, detailing the opposition to AB 381. Thank you.
For the record, Isaac Tenorio, Izack Tenorio, with Strategies 360s, on behalf of our client, the Valley Health System of Hospitals. Unfortunately, at this point, we have to testify in opposition, but I appreciate the dialogue that Strategies 360 has been having with Mr. Norman, and we hope to change our opposition. In 2019, VHS took the lead on behalf of all hospitals, worked with Justice James Hardesty and other members of the Guardianship Working Group to amend SB 20. Our goal was to provide an expedient process where an acute care hospital could work with the district court and a guardian to safely transfer a proposed protected person from one healthcare facility to another healthcare facility that provides a more appropriate level of care. Our fear is that some portions of AB 381 may work against that effort. We're committed to working with Mr. Norman, and we hope to come to a positive resolution to that concern. Thank you so much for your time.
Good morning. Thank you, Madam Chair and the committee for allowing comments. My name is Leanne Wagner, Leannewaggoner. I am the manager of a guardian ad litem program in Douglas County called Special Advocates for the Elderly, also known as SAFE. SAFE is a volunteer-based program supported financially by Douglas County and has been in existence for more than 10 years. SAFE volunteers advocate for the best interests of adults during a guardianship proceeding. Currently, our district court judges appoint a SAFE volunteer at their discretion, and typically when their cases of family conflict exist or concerns of financial exploitation, abuse, or neglect. I sit before you today in opposition of Bill 381, specifically the section that relates to guardian ad litems or GALs going forward. The first proposed addition I object to states that a GAL may not begin any advocacy services for 21 days to allow the protected person to object. While I support the ability of a protected person to object, the proposed delay severely defeats the purpose of an advocate who is assigned on behalf of a vulnerable person who is facing abuse, neglect, exploitation, and may be in need of immediate interventions. The second proposal changes the language that judges shall appoint a GAL rather than may. This eliminates the discretion for judges and will create a burden on our existing program. Not every guardianship case needs a volunteer GAL assigned, and in fact, the majority of guardianships do not. Lastly, number 7 requires the court to set an hourly rate of compensation for the GAL. I am adamantly opposed to this section, and again, I stress that we're a volunteer-based program, and additionally, it will add a financial hardship to the protected person's estate, which has already been talked about this morning. I appreciate you taking the time to hear from a local rural program in our state. If this legislation passes as written, it will have severe and detrimental impacts, not only to our volunteer program, but to the people it's intended to protect. I have submitted suggested amendments via email, and I thank you for your time.
Good morning, Madam Chairwoman. My name is John Michelson, and I thank you for the opportunity to appear here today. It's JOHN-MICHAELSON. And we prepared a PowerPoint. I serve on Nevada's Permanent Guardianship Commission. I'm a co-chair of the Rules Committee. We handle hundreds and hundreds of guardianship cases, and I just heard about this legislation 48 hours ago. So what you're hearing here is an extremely, we submitted in writing a lot of objections to this, but I think it's high time in Nevada that we try to start to get some collegiality and perspective going on guardianship. And I wanted to do that by trying to
Okay,
talk to
sir,
this.
I'm
Yeah.
going to ask you, this is
Please, yeah.
in testimony of opposition, so it's very atypical to present. This isn't a presentation.
Okay.
So have you submitted your PowerPoint to,
Yes, yes.
and, okay, so it's to the committee and it's on
Yes.
Nellis? How many slides is this?
Like 4 or 5 slides.
Okay, so I'm going to ask members to pull it up on your, on Nellis. And could you just briefly explain what it is? Because again, this is not a part of the presentation, but we do want to hear your opposition. So if you could just briefly explain your points.
And
And
this
they
is-
will pull up the PowerPoint and review, but we're not reviewing the PowerPoint right now.
Okay, but I want to point out that that's because I've never set foot in this building before.
Oh, no, that's-
And I'm very nervous about it today, and I'm okay saying that, but I want to say that's relevant, I think, to this because I suspect that many people here who are voting on this have not, or maybe presenting or having opinions on it, haven't actually been in a guardianship case recently. So for example, there's testimony here about temp guardianships being granted and people taking their money away. I'm sitting here thinking, I don't know if we've granted a temp guardianship, and we have Judge Walker here comment on it in the North in years. I mean, maybe 1 or 2. We haven't had a temporary guardianship granted in the South in quite a while. I mean, they do happen here and there occasionally, but the problem is they're used in a scary fashion based on what happened years and years ago to justify even further choking and tightening a system that is out of control right now. We can't move forward on things. And so basically this was just to give a little bit of background about us. I was going to talk about, we can skip that. Again, I've never done this before. This is my mother. She suffers from Alzheimer's. It's pretty severe right now, and I'm trying to spare her dignity to go in and talk about some of the things that have happened. So this is very personal to me. She's in a facility right now. We can skip to the next one. The reality of incapacity. I am told that we have a 1-minute video that that's visceral, that I think the committee members should see. I'm told that we can't play it up here, even though it was submitted, it was approved, but I believe...
Sir, it was also submitted after the deadline, and that's why it's not loaded yet.
But the manager was kind enough to give us a time frame, and we did submit it within that time frame.
Okay, the limit is 12 p.m. the day before for everyone. That's why it's not loaded yet.
Okay. Well, that's okay. I don't mean that critically. I just mean it's important, I think, sometimes to see another side of this. And the committee members, I'm told, might be able to pull up the video. It's 1 minute and 15 seconds long. And
Sir, could you just speak to the opposition, though? So we understand there's videos and PowerPoints, and members are, I'm looking right at their screens right now, and they all have them all up, so they are reviewing. But could you just articulate your...
The opposition is that we talk about guardianships as taking away people's rights, but I represent this gentleman that was here for Valley Health Systems. I'm the attorney that represents them. And the flip side of that is the hospitals and other facilities are viscerally criticized for an unsafe discharge. So if you put someone out of a hospital and they're not protected, there's liability for that, there's optics of that, it's terrible. But the problem is, as these new legislation comes forward, we keep making the bar higher and higher and higher, and we present it here as though we need some transparency. We need an order. We handle hundreds of cases. I can't even remember the last time I got fees where there wasn't an order. But yet that's presented here like we have no transparency, there's not any orders supporting anything. Can I steal this water?
Yes, of course.
Just take one
That's
little
what it's there
sip
for.
here. Yeah. We're presenting this like what I'm saying is I'm proud of what Nevada's done. We have a right to counsel. I go, before the pandemic, I go to all the best conferences around the country, and it's true. Now Nevada is talked about as one of the model states. What we've done is good. But the pendulum, you'll hear the concept of a pendulum swinging. A lot of people who are involved know that the pendulum has swung way too far, and AB 381 takes it to a whole nother level here. And so, can we go to the,
Sir,
yeah.
Again, we have the slides, so I'm going to ask you to wrap up your opposition. Like I said, everyone's reading the slides right now. I'm looking at there. And again, this is atypical. This is not, and I understand it's your first time presenting.
Yeah.
But what doesn't happen is we don't have presentation during opposition. We don't generally have videos and slides. People are more than welcome and invited to submit letters and submit those things, but it's not a presentation coming from the opposition. So, sir, I'm going to ask you, because you've been granted a nice amount of time, so I'm going to ask you to be concise and tell us your opposition with the proposed language in the bill.
It's difficult. You can maybe just cut off my microphone. It's difficult without context.
Okay, that's, you don't want me to do that,
Okay,
so.
it's preventing guardian ad litem because legal aid claims that they are limited to only a client-directed model, which means, like my mother, if I had time to tell a little bit more about my mother, it means that they take a position that is whatever the client says. Even when medical evidence says they don't have a concept of what they're saying. So when they don't believe the guardians, who I represent, who's the family member, the guardians are saying, this is what I want. Then the criticism is, well, you're just after the money. So that's why we need a guardian ad litem. We need the ability to say, hey, we need a neutral party. Probably in some cases it's going to be an attorney who is paid at their rate to understand these issues, to give what's called a best interest perspective. That's another model that's there. And so I'll just close by saying I included in the materials the story from NPR 2 days ago about Oregon and California grappling with these issues. They call it a war of compassion. It's not true that one side is so compassionate and the other side is not. And I also want to say, as a practicing attorney, the members asked about least restrictive means, less restrictive means. All of those, and we have some passion on that side, and I respect that. I talk about that with my clients. But a power of attorney or a supported decision-making document, that can't be done in most cases if the person's already in a facility or if they've lost capacity. It's too late. And so the real enemy that we're fighting, and I want us to come together and please run this through the Guardianship Commission, where there's stakeholders there that have different perspectives. If we can do that, I think we can come to an understanding that everyone here wants the best for Nevada. We want the best for vulnerable people. And the issue is not, this is the hardest area in the world to collect attorney fees, and I'm one of the last attorneys standing. I was going to tell you why that is. I represent most of the hospitals. I've had 20 other law firms tell me, I refer everything to you. I mean, the best way to hurt me is to allow other law firms to come in and practice here.
Okay, and I thank you for your testimony,
Thank
sir.
you.
And I ask that you reach out to the bill presenters.
Now that I know about it,
Oh,
I will
okay.
do that. And I have reached out before, I will say.
Yes, and this bill actually did come from the Interim Committee on Senior Citizens, Veterans, and Adults with Special Needs. So this was flushed out last year during the interim and during that interim process. And I encourage everyone to pay attention to the interim committees. People don't realize that we're not just legislating, while we may only be actually making laws, passing bills and making laws during this session, but we have robust interim committees for all of our standing committees, and that's where we actually do a lot of flushing out and of different ideas and proposals and stuff. And so this bill actually came and was voted out of that interim committee. So it's not just a new idea that came out of nowhere. There was a process where it had been reviewed and people presented and spoke and things like that. So it's not just brand new in the past 48 hours. But I do encourage you to reach out to Assemblyman Nguyen and Mr. Norman on this. And I know that they're always very workable to, very agreeable to continue working on legislation. So I thank you. Our next person, please.
Thank you, Madam Chair. My name is Ammon, A-M-M-O-N. Last name is Francom, F-R-A-N-C-O-M. And I am an attorney with the law firm Michelson Law. I have been practicing in guardianship for 5 years. So I basically came into guardianship, and I've been full-time for that 5 years. All my time has been in guardianship. When I started, we were citing the AB bill and the Senate bill before they were codified. So I've become very familiar with these guardianship statutes and their application. And I would urge that you do not pass this bill at this time. I would urge that you please, well, I guess you can't mandate it, but I believe that the Permanent Guardianship Commission needs to debate this, and they need to look at these provisions, and they need to come to a consensus on this bill so that guardians have their interests represented and the protected person has their interests represented, and the court-appointed counsel has their interests presented, and the judiciary, the judges as well. The current law, we're coming to an understanding of what the provisions as they're currently written mean. We're finally starting to get some case law about these provisions, and I think that this is very bad timing to change these provisions and these laws because it's going to reset the cycle. The last 5 years of work at the district court level is going to be rendered moot if these provisions are entered into law and codified. We will have to start over again with going through evidentiary hearings, trials, and appeals and case law, and it's a bad idea for the continuity and the purpose, and it's bad, in my opinion, for protected persons. The uncertainty of law is a bad idea for protected persons and guardians. We need to be able to counsel them on what we know that these provisions now mean based upon case law and district court orders. In specificity with regard to the provisions, the slides that Mr. Michelson presented, there's a lot of bullet points with a lot of my criticisms and Ms. Tigritt's criticisms included. So if you'll read through the changes, I believe, are detrimental to guardianship law as it stands. I will let you know that temporary guardianships in Clark County were granted regularly 5 years ago, 4 years ago. In the last 3 years, I've had maybe one temporary guardianship granted. I believe that the grounds were there. I believe that the emergency exigent circumstances were there. The court disagreed, denied my petition. I have had one emergency guardianship petition granted that was in a minor guardianship where the guardian had suffered a stroke and was hospitalized long-term, and we needed to get a successor guardian in. So that's the one instance I've had where in the last 3 years where a temporary guardianship was granted, and that was minor guardianship law, not even adult guardianship law. With regard to the guardian ad litem provisions, I believe that the proposed provisions are too restrictive. I believe that they take away the district court judge's discretion, and a very valuable tool that I have seen the district court judges employ to the benefit and the protection of protected persons. With the implementation of the 3-week waiting period, and then if an objection is lodged, having to wait until there's a hearing on that, that could be up to 4 weeks. You're talking about a 7-week time period that the protected person needs the guardian ad litem to get in there and visit with them, figure out what the circumstances are, and report back to the court before 7 weeks is over, especially if an objection is lodged. So the guardian ad litem provision and the provisions to limit the amount the guardian ad litems can be paid to a fiduciary rate, that will severely limit the court's ability to appoint an attorney to be a guardian ad litem, such that the attorney can understand the complex issues facing the protected person and give the court a good best interest analysis representing the protected person's best interest. it's going to limit and curtail the court's ability to get that perspective. With regard to the restrictive orders and the proposed amendments to restrictive orders, I will let you know that I believe that the current statute is already too restrictive. I have tried to get restrictive orders in place in 2 cases, only 2, and they were both denied. I believe that they should have been granted, but in both of those cases, the district court judge denied me having a restrictive order put in place to stop people from coming to visit the protected person that I believed and that the guardian believed were detrimental to the protected person.
Okay, and thank you, sir. I'm going to ask you as well to wrap up your testimony and submit any additional comments you have for the record to us.
Okay, thank you very much. With regard to attorney's fees, they're too restrictive as well. I think the definition of clerical tasks is overly broad. We have cases in Clark County where the district court judges have handed down decisions specifically stating what is clerical, what is paralegal, what is secretarial, what can or cannot be awarded from the guardianship estate. If this law is passed, it's going to erase this local precedent and we'll be out of luck again. And I think that they're overly broad.
Thank you so much.
I'll wrap up. Thank you for the time.
Thank you for your testimony. And I just want to remind people that we typically ask for a 2-minute testimony. And so that there's no question later that the opposition has been given a very fair amount of time per individual.
Thank you very much.
Thank you so much for that. Next.
Sorry, short arm syndrome.
We all sit down there, I understand.
Rachel Tygret, Racheltygret. I am also an attorney in Clark County, practicing in the area of guardianship. I'm not going to overly reiterate what's already been said. Guardianship is a very nuanced and complex area of law, and there are not a lot of attorneys anymore working in this area. My biggest concern is that the bill as it stands will cause potential guardians from wanting to pursue protection for their family members or loved ones, and that it will prevent attorneys from being able to adequately represent those who cannot navigate the legal system on their own. While we do have a very amazing self-help center, it doesn't fix the problem that this area of law is not for a layperson to navigate on their own. And with that, I do appreciate the commission taking our oppositions at this time. Thank you.
Thank you for that.
Thank you. Amber Handy, AMBERHANDY. I am also an attorney, but I come from the rurals. I practice in Lyon County, Carson City, Douglas County, and Churchill County. What my major concerns are deal with the Section 7 and the restriction of attorney's fees, specifically the restriction of attorney's fees to represent a petitioner or a guardian in the guardianship proceedings. So it's not just, we don't have two worlds here. We're not just having a family member petition or the public guardian appointed. In some of these rural counties, the public guardian has taken a position that they cannot be the person who, or the entity who is petitioning for the need of the guardian. And so we have family members, neighbors, we have even skilled nursing facilities who are in a position that they need to file the petition in order to seek the appointment of a guardian. And normally, what is required at the filing of the petition is a notice of intent to seek the reimbursement of fees. Now, those reimbursement of fees are not an automatic thing, and a lot of these a lot of my fees generally are borne by those individuals who are filing the petition, but we need to be able to give them the ability, if the protected person's estate has sufficient funds, if the judges have determined that the services that have been provided to either the petitioner or the guardian are necessary and reasonable, that is it's already within the discretion of the court, and the proposed amendment here just removes the discretion from the district court judges and the ability and frankly the incentive for a lot of these well-meaning individuals from filing a petition. I would also note that my reading of this statute would also, and these changes would also likely discourage many of these well-meaning individuals, whether they're family members or whether they are neighbors or whether they are these skilled nursing facilities. And so the burden of these members or of these well-meaning individuals to help our vulnerable citizens is going to go to the wayside, and so the burden of that would go to the public guardian's office. I don't know if you know, but we have a lack of resources in the rurals, and our public guardians are severely overburdened and underfunded. And so if we're going to be shifting the burden of the guardianships, who a well-meaning individual family member could have stepped in, and we're going to eliminate that and then shift the burden to the public guardian's office, then we also need to take that into consideration. I've represented...
Ma'am, and could you also wrap it up, please?
I'm so
Thank you.
sorry. I was just going to say I'm happy to provide and speak with the bill drafters. And yes, thank you so much.
Thank you so much. And again, we appreciate that. Speaking with the bill drafters, and of course, everyone is always welcome to contact individual legislators, continue to speak and work with the bill, I should say bill sponsors at this point, not drafters, but the actual sponsors and presenters of the bill, as well as submitting any additional information that you would want on the record. At this time, is there anyone else here in Carson City in opposition of Assembly Bill 381? Broadcasting, is there anyone on the line?
If you would like to testify in opposition to Assembly Bill 381, please press star 9 now to take your place in the queue. Again, if you'd like to testify in opposition to Assembly Bill 381, please press star 9 now. Caller with the last 3 digits, 500, you are unmuted and may begin.
Good morning. My name is Dara, D-A-R-A, and my last name is Goldsmith, G-O-L-D-S-M-I-T-H. Good morning, Chairman, Vice Chair, members of the committee, as well as all of my colleagues and associates who have participated and testified both on behalf and in opposition of this bill. Today I write, or speak, in opposition of Assembly Bill 381. I'm a shareholder in the law firm of Goldsmith & Guyman in Las Vegas. Goldsmith & Guyman is one of the largest and oldest 100% women-owned law firms in the state of Nevada. Since 1996, we have actively participated in representing underserved populations. We've been recognized over the years for our work in support of pro bono services by Nevada Legal Services, Legal Aid of Southern Nevada, and the Southern Nevada Senior Law Program. I've served on the State Bar Board of Governors for 8 years, the Clark County Board of Directors for 7, the Nevada Community Foundation for 12, culminating in serving as the chairperson for 2 years. I'm a Martindale-Hubbell AV-rated preeminent listed attorney, and I've been listed in Mountain State Super Lawyers, Top 50 Women Business Attorneys in the Mountain States, and other statewide and regional honors. I was previously trained and served as a mental health hearing master in Clark County, Nevada for the 8th Judicial District Court. I've practiced in the areas of elder law, trust, and estate planning and litigation for more than 30, and guardianship for more than 31 years. I've represented clients throughout the state. My clients have been private and public guardians, protected persons, professional fiduciaries, and a variety of family members concerned for a loved one. I've not only established guardianships, but I've successfully terminated guardianships on behalf of protected persons and or guardians who recognize that a guardianship is no longer needed.
Okay, ma'am, can you speak to your opposition of the policy that's being proposed, please? with you?
Absolutely.
Thank you.
A lot of my other comments, yes. Let's be clear, Assembly Bill 381 is not a technical correction to existing statutes. It represents substantive changes which will negatively impact the families and individuals who are in need of guardianship by imposing substantial hurdles in the ability to obtain a guardianship, to retain counsel of their choosing, and to ask for and compensate guardian ad litem to review specific issues. That is, speak for the protected person's best interest, provide an unbiased look at the protected person's needs, and provide that information as boots on the ground to the judge, and most importantly, to help families who are being negatively impacted by guardianship proceedings. These guardian ad litem often possess skills, knowledge, and experience that go beyond the day-to-day skills that the judges and counsel for the proposed protected person or protected person possesses. Further, the imposition of the additional medical hurdles make it next to impossible to deal with a protected person's rights unless they're currently institutionalized or hospitalized. Many of these proposed guardianships involve family members whose condition has deteriorated into dementia. Sometimes they face issues like when a husband and wife are named as one another's respective attorneys in fact. Even though they're hospitalized, the hospitals are not able to speak to address the affairs of another to the next person in line. Unless the proposed guardian is in a position to have the individual evaluated, it will be difficult for family members to obtain the necessary documentation. Nevada already requires the opinion of a licensed medical doctor, so there's no benefit in requiring an additional hurdle or additional evaluation. Second, the limitations on the compensation of guardian ad litem and attorney places burdens and restrictions on the judiciary, families, and attorneys. Over the past years, fewer and fewer attorneys are practicing in this area. Many of the attorneys are selected to participate due to their experience in estate planning, mental health, first-party special needs trust, third-party special needs trust, pooled income funds, and others that are offered by other states as a vehicle for Medicaid planning, VA licensing, use of annuities, family law, and annulments. When a guardianship petition is filed in Clark County, Nevada, where the proposed protected person does not already have counsel, Legal Aid Southern of Nevada automatically is appointed to protect the protected person's rights. In my experience, they immediately file an objection to the guardian's counsel's fees. Many times they haven't even spoke to their client. Some of the clients are not able to have a meaningful relationship and to direct their
Okay,
counsel.
ma'am,
Rather
I'm going to
than
ask you
acting
to wrap up your comments, please.
All right. Many of the adult guardianships are the result of dementia that will result in death. Section 10 of the bill prohibits the judge from putting in place visitation or communications with a protected person. The judges should have this discretion. Let's be clear, families retain counsel in these matters because they're unable to get resolution without judicial intervention. And they determine that they need an attorney to help them do this. The judges involved in
Okay,
these
ma'am,
matters
I'm
have
going to ask
significant
you to wrap
experience.
up your comments, please. We're at like 7 minutes. Can you please wrap them up?
Of course. The rest of my comments are located in a 4-page letter as well as comments that I posted on the site. And I look forward to the opportunity to work with the sponsors of this bill and want to point out that none of the members of the elder law section of the State Bar were invited to participate nor made aware of this until this week. So I appreciate your listening to me this morning, and I will close it with just announcing my opposition to AB 381 as drafted. Thank you.
Okay, thank you so much. Next caller.
Good morning. My name is Tracy Bowles, Traceybowles. I am the public guardian in Washoe County. I'm here to testify for my office in opposition to Assembly Bill 381. In short, I believe this bill seeks a legislative solution to an administrative problem, and removing the judicial discretion within this bill has unintended consequences in an effort to solve problems in a narrow population within guardianship. This bill does have some specific changes that could add value to a protected person's life, but the sweeping changes where guardians or petitioners are not able to seek reimbursement for court-approved legal fees and judicial discretion is reduced are an unnecessary and potentially harmful overreach. Guardianship is a complicated legal process that families and well-meaning individuals in our community already struggle to navigate, and now this bill seeks to remove any ability for the reimbursement for counsel. This may leave vulnerable persons unprotected or push this burden in the direction of public guardians in the rural counties of our state. This is an unnecessary change in law as the court already has discretion to approve or deny legal fees. Section 8 of this bill fails to identify the burden of proof a petition must meet in terminations of guardianship while stating the burden of proof for those who seek to oppose the petition. Further, if the protected person prevails on a petition for termination or modification, this bill entitles the protected person to seek attorney's fees from any person who opposes the petition. Well-meaning family, professional, and public guardians would be faced with a dilemma of whether to uphold their duty of acting in the best interest of the protected person while risking the potential financial liability of an adverse ruling, or avoiding the financial liability and not upholding their duty as guardian. While legislatively removing the ability for guardians to seek attorney fees and imposing financial ramifications on a guardian may limit a guardian acting in bad faith, it similarly may limit a guardian acting in good faith. Section 12 of this bill further provides that a guardian cannot recover attorney's fees incurred if removed as the guardian, but there are valid reasons why a guardian may be removed, and unnecessarily removing their ability to seek legal fees seems punitive in those circumstances. We would be happy to work with the sponsors of this bill, or in light of the plethora of comments I've heard today, perhaps the interests of our vulnerable populations would be better served if considered within the Guardianship Commission. Thank you for your time.
Thank you so much. Next caller.
Callers, if you have recently joined and would like to testify in opposition to Assembly Bill 381, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 381, please press star 9 now.
Good morning. My name is Elizabeth Brickfield, ELIZABETHBRICKFIELD, and I am an attorney practicing in Southern Nevada in the area of guardianship and related fiduciary matters for the past 26 years. I am also a member of the Permanent Guardianship Commission, and to be clear, I am a longtime volunteer for the Legal Aid Center of Southern Nevada. And actually, when the article in the New Yorker was mentioned, I am one of the attorneys who was quoted in that article regarding the condition of guardianships in Nevada at that time. And I have written and I speak in opposition to Assembly Bill 381. I am not going to reiterate the comments that have been made. They're all well reasoned, both for and against, but I want to add some additional comments. First, with regard to the extent the bill seeks to have additional information placed into the public record about an individual's medical condition in seeking a temporary guardianship, that can easily be construed as violating that individual's HIPAA rights. And we should think long and hard before we extend the statute as to what has to be presented in a petition to a judge for a temporary guardianship for medical reasons. Similarly, in a temporary guardianship for financial reasons, to the extent that we put more information into such a petition and specific information, we are simply giving a roadmap to an exploiter. And I don't think that's the goal of anyone in this matter. On the contrary. I also want to say that with regard to families' need to visit with their relatives, many of these guardianships in the adult area, as we all know, are the result of dementia and other deteriorating factors. And to prohibit a judge from exercising his or her discretion to allow a family member visitation will, in fact, limit a family's ability to seek closure, to say goodbye to relatives, to come together and recover from this experience. Dementia, the loss of family members, as we all know, is not pleasant. It's a grief experience. And all of us, whether estranged or not, should not be prevented from seeking a court's ability to say, yes, you may say goodbye to your mother. So that's all I have to say. Everything else I've had in my written submission, and I thank you for listening to me this morning.
Thank you for your testimony. Next caller.
Caller with the last three numbers, 530, you are unmuted and may begin.
Good morning. Thank you for giving me the opportunity to speak in opposition to Bill AB 381. My name is Travis Clark. I'm an attorney in Washoe County. I practice in Northern Nevada. I have been working in the guardianship field for the last about 5 years, and I would like to adopt many of the comments that were made today on the record regarding the attorney's fees provisions and other provisions that are restricting the protected person's rights to meet with other folks. What I would like to add to this commentary is regarding the private information that is now being sought to put into the petition, such as the phone number and email of the protected person. These are vulnerable human beings, and to put that information into the public record seems incongruent with the Protected Person's Bill of Rights, in which they have a right of privacy. These phone numbers and contact information can be placed in ancillary documents, such as the family court does with the family court information sheet, such that these are protected from public view, but the interested parties who are appeared in the matter and who need the information can still access the information without putting the protected person out into putting their private information out into the world, such that they can be subject to more scams and the financial vulnerability that they already experience. That is what I wanted to add. Thank you for giving me the time to testify this morning. Have a good day.
Thank you so much. Next caller.
Caller with the last three digits, 375, you are unmuted. Could you please press *6 to unmute your phone? You may begin.
This is Kathleen Jones with the Elko County Public Guardian's Office, KATHLEENJONES. I'm representing the Elko County Public Guardian's Office, and I would support opposing this bill with my colleagues, and I would also encourage the bill drafters to have a discussion with the public guardians, as we are experts in our field, and I believe that we could give a lot of input to this bill if there's any changes. In addition, I would also encourage that the rurals be included in some of this bill draft if it's to change, as I feel that we have different resources as needed to support our protected persons, and those are different from the bigger cities. So thank you for listening, and I appreciate your time.
Callers, if you have recently joined and would like to testify in opposition to Assembly Bill 381, please press *9 now. Chair, there are no other callers choosing to testify in opposition at this time.
Okay, thank you. Then we'll open it up to testimony in neutral. If there's anyone here in Carson City that would like to testify in neutral.
Good morning, Madam Chair, members of the committee. My name's Egan Walker, EGAN-WALKER. There we go. Rumor has it I'm that Judge Walker guy. Good morning. Welcome to my world. My comments are these. My co-chair in the Statewide Guardianship Commission and I, Judge Linda Marquis, would offer to you our services. We were not aware of the interim meeting. We were aware of some of the concerns that the legal aid communities had raised to the interim committee. I want to be clear, they had made us aware of some of those concerns, but we were not aware of the meeting, and the commission was not allowed or didn't give input at that. We could have if we had been aware of it, I suspect. All of the actors in this area are very motivated, as you can tell. You would be very proud of the private and public bar across the state in the guardianship headspace. The movement that's happened in Nevada is remarkable. I've had the privilege of bearing witness to it now across 6 sessions. I was a member of Guardianship Commission 1, Guardianship Commission 2, and then Judge Marquis and I made Justice Hardesty very angry, and he appointed us co-chairs of the current commission. I just want to offer our availability to you and to the authors of this legislation. There are some unintended consequences in this headspace anytime you seek to finesse the statutes. Let me be clear, the legal aid communities in this state do magical work. I am so thankful for Northern Nevada Legal Aid, for Legal Aid Center of Southern Nevada, and for VARN. I am also thankful for the guardianship bar. You would be incredibly amazed at the work that the John Michelsons and others in the private bar do in this headspace. Please, 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 however, as you consider any of these legislative changes, reach out to us in the Guardianship Commission. Between Judge Markey and I, we have a perspective across time and across now, as I said, 6 legislatures about how this came to exist, why it exists the way it does, and how it needs to be improved. I had the privilege of being one of the co-author, not the primary authors, of 159A. It has a lot of work it needs to be done. I'm the first to admit that. But we need to do it in thoughtful, integrated ways that don't leave my rural colleagues out. I welcome any of your questions.
Thank you for that, and we appreciate your testimony and, again, your willingness to come to the table with the bill presenters. Thank you for that. Anyone else in opposition? I'm sorry, anyone else in neutral? Broadcasting, is there anyone on the lines in neutral, please?
If you would like to testify in neutral for Assembly Bill 381, please press star 9 now to take your place in the queue. Again, if you would like to testify in neutral for Assembly Bill 381, please press star 9 now.
Good morning. Tanya Brown, spelled Tonjabrown, Advocates for the Inmates and the Innocent. We are in neutral on this bill, and we've heard concerns about unintended consequences. This is a work in progress, and also room for improvement. And I want to briefly touch on something. As an advocate for the inmates and the innocent, I have been made aware of a certain case out of Reno dealing with guardianship, in which the daughter of a woman who is now in a facility became the obtained guardianship over the mother. The son would go and visit at this facility. He noticed that she was being unkept. She was lying in her own urine. She had bruises on her. He became concerned. The mother wanted to leave. The mother wanted to go and visit her brother who lived in another state. So he wound up getting in contact with an individual who put him in touch with another person, a person who was retired law enforcement after 30 years. He went to the facility with some paperwork, and the facility gave the mother to the son, and they left. The next thing you know, they're both being charged with felony crimes. Now, so this is kind of our concern, and also it's this. When should a person or a judge put a gag order on an individual who maintains their innocence? The individual has been vocal about his innocence. The judge put a gag order on him to shut up about it, and now he violated it, and now he has to serve jail time for maintaining his innocence. This is simply wrong. And then when we talk about a work in progress and room for improvement, I think you need to look at this case, State versus Roger Hilligas, State versus Stuart Handte, Handte, and see what's going on, because that's where the room for improvement needs to go. People who are innocent are being prosecuted because they want to help their loved ones or because they're not being provided for, and this needs to be looked into. We would appreciate this in the future, and I think this case, and not just this case, us, but throughout the country, advocates dealing with guardianship are looking at this case because it could affect them, and now Mr. Handte and Mr. Hilligas could be looking at several years in prison. Thank you. Have a good day.
Thank you for your testimony. Next caller.
Chair, there are no other callers to testify in neutral at this time.
Okay, thank you for that. Then I will welcome, what if I had not welcomed? I will welcome back the bill presenters for any final remarks.
Chair, members of the committee, thank you. Obviously, I have a lot of new friends to talk with today. I will say, you know, I represent the coalition, which is advocacy law firms. We're going to advocate in the Guardianship Commission. We're there at all those meetings. We're going to advocate when it comes to developing local rules. We're there for that. When we have an opportunity to fix things every other year at the state legislature, we're going to bring that to this body. I would point out, you know, a quote, additionally, the court should be required to make specific findings in any order appointing a guardian. That includes a conclusion that no other less restrictive means are available to address the needs of the proposed protected person. This is from the guardianship final report when we underwent those reforms back in 2017. We're in 2023, and if you read the bill and what we're asking for that, right? We're asking that if you order fees, the judge shall, right? We moved it from a may, shall look at this list of factors and give a written order with showing the work. Why should you take the life savings of someone? We're not saying you can't seek fees. If there's work to be done in the, you know, as Assemblywoman Cohen said about how we're dialing in those fees, we're ready to engage and willing to do that work. But we are never going to stand for the proposition that there should not be a written order. And the reason we're asking is because we have cases where we're not getting a written order that's showing that they considered that list of factors and like show the work, like in a math class. Further, I think, you know, there was a comment from, and I don't think safe from Ms. Wagner. I think, you know, when I say it's a work in progress, we've gotten input from the Judiciary, from the courts, the public guardian, and so we have some things we've changed. And I think that we already have a change contemplated in that area that I think will address her concerns. You know, the reality of when language drops and when you're able to amend it, and throwing an amendment up at like 9 o'clock last night, I think serves to confuse everybody involved. So we do have changes, and you know, obviously based on some of the comments today, you know, in opposition, there were some really good thoughts that we can incorporate. And so, you know, I want to thank the commenters, both, I don't know that there were any for, but the commenters in opposition, and I look forward to working with them. But from our perspective, we're going to use every avenue we have to advocate for our clients. And where we differ from all the commenters is we represent the protected persons, right, around the state. And so I appreciate your time. Thank you.
Chair Miller, member of the Judiciary Committee, Uwego in District 8 for the record. Again, thank you for your patience. I'm, as you all said, members of the committee as well as the opposition have said, as well as neutral testimony, work in progress. This is truly still a work in progress. And I look forward to work with everyone, all the stakeholders, to make sure that we are doing the thing that we set out to do. It is patient protection, and that is why we're here. And so I got one opposition email last night at 9 p.m., and I met all the opposition today. So I really encourage all of the committee members to be patient with us, and as well as all the opposition. We're going to work this out, and we will bring all the stakeholders to the table. So thank you, Chair Miller, and the rest of the committee for considering hearing AB 381. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 381. Our last item today on the agenda is public comment. So if there's anyone wishing to make public comment, again, this is not to comment on the bills that we've already heard today, but on anything else that's under the purview of this committee. And again, we ask that you keep your public comments to 2 minutes each. Is there anyone here in the room in Carson City that would like to make public comment? Not seeing any. Is there broadcasting? Is there anyone on the line?
Callers, if you would like to provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis, hogtied for over 40 minutes and asphyxiated to death. I'd like to talk about the constitutional violations that are occurring at the Washoe County Jail from being denied proper medical treatment to derogatory and racist comments from deputies to being completely traumatized by the sounds of other inmates being brutalized by deputies. Young people who aspired to join the law enforcement field, but after experiencing the degrading and inhumane ways deputies at Parr Boulevard treated human beings, they lost total respect for the profession. People make mistakes. Jail is the punishment, not a death sentence like my brother received. Verbal abuse, physical abuse, or psychological abuse. For too long, the treatment of those in custody at Parr Boulevard has been ignored and continues to be ignored by elected officials. Here are some of their comments from community members. For you non-believers, they hurt my 85-year-old father who had a brain tumor, cancer, dementia, and a heart condition. When I finally got a judge to release him, he had a gash on his head, blood all over his white hair. I asked the deputy what happened, and he said, I didn't know, I wasn't there. He hadn't committed any crime, and I begged for them to get him to a hospital. They never took him to a hospital. Another comment, I was there right when I turned 18. I had always dreamed of being a cop, but that quickly changed. I wanted to be a cop so I could help other people, but the guards were so cruel. Yes, I'm sure some people are very bad, but most of them were minor crimes. The guards would scream and call us maggots and POSs, acting if we were subhuman. There is no way I could ever treat someone like that. It takes a special type of person to be able to be cruel like that. Another comment, I was actually in Parr Boulevard for 13 hours last July. The deputies mocked people's mugshots in front of them. It's actually a game they played trying to take the worst possible mugshot, call inmates' names, cussed at them. The scariest thing that I saw was a girl going to withdraw, fell asleep on the bathroom floor for 4 hours before anybody noticed her face had vomit all over it. When they got her out, she could have died. This was in the booking. She was like 19 to 20 years old. The officers were having too much fun with people's mugshots to pay attention. Today marks 3 years since 21-year-old Nicholas Sedano was shot and killed by Reno police. He was unarmed. Please keep his family in your thoughts today. Please support bills that promote transparency and accountability. Thank you.
Thank you, Ms. Grant.
Chair, there are no other callers to provide public comment at this time.
Okay, thank you for that broadcasting. Then with that, I will go ahead and close public comment. We have completed all the business for today. Just want to let everyone know that we will be starting at 9 a.m. on Monday. And with that, this meeting is adjourned.